about introducing this bill that will provide more justice for exonerees. There's I think there's a false knee-jerk reaction to say we're providing justice for exonerees. And we just want to start off the bat by saying we cannot provide justice for people that are wrongfully convicted in Wisconsin. Our justice system in the context of time and place is among the best the world's ever seen. But we also have to recognize that sometimes that justice system fails. And when that happens is individuals are hurt. Their reputations are hurt. Their financial well-being is hurt. And the very least we could do as a state of Wisconsin is try to put them in a place where they're less hurt. So what we're doing today is we're raising the amount that could be awarded to individuals that are falsely incarcerated. Right now the limit is $5,000. We're raising that to $50,000 a year to a max of $1 million. This is just something that gets them off to a right foot. If you think about all the time they've lost where they couldn't buy a home, couldn't make progress on that 30-year mortgage. If they get out when they're 50, a 30-year mortgage means that they're going to have a mortgage until 80 years old. They didn't have the time and money to go to school, and didn't have time and money to take care of children. So once again, we're not providing complete justice and exoneration to make it completely right, but this is one small step as a state that we could say, hey, we're going to make it more right. And so we wanted to have some of the exonerees here with us today. But with our low compensation amounts in Wisconsin, they all have to work, so they couldn't be here. So I want to thank you again for coming out. I want to also thank everyone that worked on this bill. Senator Weingard obviously is a lead on this bill as well as Senator Risser. Senator Risser unfortunately couldn't be here today. And then also Representative Gary Hebel, who's done a significant amount of work on this bill as well, and has been an issue very close to him. And we also have today with us folks from the Innocence Project, co-directors Keith Finley and Carrie Sperling. So thanks again for coming out, and I'll hand it over to Senator Weingard.
Thank you, Dale. I really appreciate it. Thank you again for being here today. You know, victims are victims, and sometimes we can be wrong, and thank God this doesn't happen very often, but when it does happen, it needs to be corrected. And like Dale said, you know, we're looking at changing this from a $5,000 per year to a maximum of $25,000 to $50,000 a year, and a cap of $1 million. This kind of puts us in the middle of about 30 states that have wrongful conviction compensation. So we're right about, you know, in the middle there, and this is a fairer, I think, compensation than obviously what we've had. And I believe it was 1972 or 73 that was the last time that this actually occurred. So this bill allows the exoneree to enroll in a state health plan for up to 10 years to kind of help them transition back into normal life. And in order to be able to have both of these conditions, there has to be a finding of innocence by the Division of Hearings and Appeals. So there is a process that they have to go through to verify that this individual was actually wrongfully convicted. So, and finally, if a third-party bad actor is forced to compensate the exoneree, the state will recover money that is provided to the exoneree. So there's a clawback that way. So it's not a huge windfall. This is about being fair and doing things right. With these three changes, we can help the process of putting these people's lives back together. Time is your most valuable asset, and so I think this is very, very reasonable what we're trying to do here. This is long overdue, and thank you to all the work of everybody standing up here. Senator Risser, this is, you'll notice, is a bipartisan approach to try to deal with this issue, and proud to be part of this process with this. And with that, I'll turn it over to Representative Gary Hebel. Gary.
Thank you, Van. I want to thank both Representative Kuyinga and Senator Weingard for the tremendous support in terms of getting this bill to where it is today. This is an extremely important bill for those people who have been victimized by being wrongfully convicted. The exoneration that they go through and the fact that they're trying to get back into society will be greatly enhanced by the bill that we have before us today. Just to point out to you the differences, currently, if you can imagine, currently in Wisconsin, if someone is wrongly convicted and exonerated, the maximum they can receive is $5,000 a year, and the cap on that is $25,000. Think of your own life, and think of your own family, and think of what it would be like if you were taken from your family for a year, much less 5 years or 10 years. But we have those examples here in this state. And in order to, there's no way we can ever compensate someone for the loss of a year of their life by being incarcerated and wrongly convicted. But we have to make a good faith effort in this state, and we are doing that by this bill, to fairly compensate victims for unfortunately being wrongfully convicted. Just to give you an example, it's been referenced a little bit, but again, $5,000 a year up to a maximum of $25,000. The federal government back in 2004 set the guidelines at $50,000, and that was under George W. Bush. And there's no compensation cap. Other states around us, Texas, for example, Texas, $80,000 per year, Texas, when you have wrongful incarceration. And again, no compensation cap in Texas. Here in Wisconsin, we're looking to do $50,000 a year, match the federal standard. In addition, we're looking at, we have a cap of $1 million. But in addition to that, we're looking to provide health care access at the expense of the exoneree. That's not an addition. But also temporary financial assistance, which will be part of that grant, and other transitional services provided by Department of Corrections. One final note. When someone serves their sentence here in the state of Wisconsin, they're provided with services, with a plan to be successful in society. If you're wrongfully incarcerated in Wisconsin, you're basically let out the door, and there's a slight possibility you might get $5,000 a year. You're actually better off in this state right now serving your sentence and then getting the services of the Department of Corrections in the state than if you're exonerated. We need to change that. And that's the intent of this bill. And again, I want to thank the co-sponsors on this bill, the lead sponsors. And at this time, I want to turn over the microphone to two very fantastic people that we worked with on this, Keith Findley and Carrie Sperling, who are with the Wisconsin Innocence Project. Thank you.
Well, thank you very much. And I really want to thank Representatives Coenga, Senator Wangard, Representative Hebel, and Senator Risser for their terrific work on this bill. This is an important change in Wisconsin law. And I think their bipartisan sponsorship of this bill represents what a nonpartisan issue this really is. This isn't a left-right issue. It's not a Democrat-Republican issue. It's an issue of basic fairness, justice, and actually, frankly, well-being for all of us, because it's in all of our interests to ensure that those whom we've wrongly convicted are given the assistance they need to re-enter the community in a productive and fruitful way. You know, Wisconsin used to be, at one time, was a leader, a national leader when it came to doing justice for those who were wrongly convicted when it adopted its compensation statute many decades ago. It has now fallen to dead last among those states that provide compensation through statutes. So it's well beyond time that we address that problem and fix this. You know, there's as Representative Coenga said, you really can't provide a full measure of justice for people who've been wrongly convicted. But as folks who represent those who've been wrongly convicted and watch the struggles they go through, we can tell you that the experience is horribly damaging, traumatic, disruptive, and that anything we as a society can do to provide some measure of justice and some assistance to their reentry is very much needed, appreciated, and as I said, in the interest of all of us. And I think, quite frankly, that experience has shown that providing compensation through this kind of statutory scheme is a far better way to try to address the problem than relying on lawsuits, which are haphazard, very difficult to meet, and can only provide assistance in a very small spectrum of needs. This bill goes beyond just financial compensation and provides a whole package of assistance to ensure people are given what they need to help them re-enter the community. Did you have anything you wanted to add?
Sure. I'd just say that, you know, fixing this sort of outdated compensation statute is, to me, the model of good administrative justice in the criminal justice system, because, you know, we look at when we release people from prison, and I think someone's already mentioned this, of whether they're on a path to success. And that's a big determinant of whether we release people into the community. And here, we have clients who are released with really nothing because everything's been taken for them. And so the path to success is almost insurmountable for many exonerees who have lost everything. So I think it's just a matter of smart administration.
So thank you all, and thank you very much.
Are there any questions?
Would exonerees still have to apply for these funds, or would it be automatic once the state exonerates them?
There still is an application process, and it would still go before the panel that makes that determination. And so it's not an automatic at all. It still has to be, the board still would make that final decision.
Would this law be retroactive at all?
We're still working out the kinks on that. Initially, we were looking at the effective date of January 1st, 1990. We're still working on that, and that's yet to be decided. It's just being introduced today. Actually, tomorrow is the National Day of Exoneration. It basically, so we're going to time it as part of that. And so that issue in terms of the effective date is currently under discussion with the authors.
What effective date did you mention?
I mentioned January 1st, 1990, but that still is in discussion, so please hold off on using that as a final element of this bill.
So this bill is not written yet.
The bill is it's in its final form. It's being sent around for co-authorization, but that part of it is still,
Does it say January 1, 1990 right now?
the current form of the bill does say that
Okay,
right
but
now.
you're looking to amend that.
Yes.
About how many people would this affect?
How many people? Currently, I believe, and maybe Keith can speak to this, but I believe there's as many as 40 in the state, 40 exonerees over the years, and I may be wrong on that.
40 since what? Since 1990?
Oh, since it's, yes, since 1990.
Can I just add to that? That number is very hard to pin down because a number of these people are gone, some have died, and as the legislators have indicated, all of them would have to go through this process of filing for a compensation through the claims process, and not all of them would be able to meet the statutory requirements for compensation. So that number is probably an outside number of people who've been legally exonerated, but yet still may or may not meet the criteria for receiving an award under this statute.
If you look at if you go to the Innocent Project website, you see some great examples of cases they've worked on, and it's really a finite number. But the reason that we're still discussing, just like any bill, we're going to go through the process, we'll have committee hearings, and based on feedback, we will look at the details, right? And so one of the questions on the date we're trying to figure out, why that's complicated, is it when they're exonerated? Is it when they go through the claims board? Is it when they're convicted? And so we got to sort that out. The reason being is typically if you make a change to criminal law, you don't go back and you don't go and retry the case. So we're going to discuss that. We're going to figure that out. Obviously, we have bipartisan support and want to do what's right and also do what's passable, right? Our ultimate goal is to pass a bill. And so we're going to sort that out going forward.
So if somebody has already gone through the claims board and has already received a compensation package, and they're within that retroactive time period, would they be allowed to go back to the claims board and claim the difference?
That's what we're going to discuss. As we're going through this process, we're going to see if there's any opposition to going backwards and opening up that process again. I mean, because that claims board is a part-time board, right? And this also changes the caps. It doesn't necessarily mean they would change the determination. I think they would. But those are the things we'll be discussing as we look to go through the process of committee hearings and amending the bill. Yeah.
So Keith and Senator Weingart both referenced the states that do this compensation. I'm assuming that means there are some that don't.
There's about 20, I believe, that actually, but they don't come up to these same limits. We can get you a list of
Are
them.
wrongfully convicted people then reliant on lawsuits in those states?
Yeah, there are
For the
a
most part,
handful of states that don't address this statutorily, and they do rely on lawsuits. Yes.
And private bills.
Oh, and yes, of course, in private bills, so, and which is, this legislature actually has some experience with. And the other option is a fairly inefficient one and sort of haphazard, and that is the legislature can always pass a private bill awarding compensation to a specific individual, and some states do it that way. But that is pretty uneven and unpredictable, and administratively not an ideal way to go about it.
And you were saying that of the states that do it statutorily, we have the lowest cap, is that right? And what is your source for that?
There's been considerable research that's been done on that. The Innocence Project in New York has collected all of the data on all the compensation we actually have this. We can certainly provide the spreadsheet. There's one state, I'm trying to remember now, there's one state that is lower than us, New Hampshire, that is lower than us, I believe on the total cap. Of 50, they have a cap of 15, but they have a higher annual compensation rate. We have the lowest annual compensation rate in the country.
I know in the past, similar proposals have been floated around and nothing's been passed. And what makes this one different? What makes you confident that this one's going to pass?
Because Dale and I are working on it.
Yes.
And I would say this, I think that when you look at, I'm sorry, okay. I think when you look at the circumstances and you look at some of the stories that have just come forward, we're starting to recognize that this has really become a bigger issue than it has been in the past. And honestly, we've got bipartisan support from both sides of the aisle. So both sides understand this, and this is about doing what's right. You know, it's about integrity. You know, you do what's right when nobody else is looking. Well, this comes up to that level. We have to have integrity in our system, and we have to be able to admit when we do something and we're a little bit weak on being right, we need to make sure that we correct that. And this is an effort to do that, and I think that's our message. Our message is that we want to do the right thing for these individuals. So, not victims again. We need to help them be productive individuals in the workforce, and you know, for some of them were incarcerated for 20 or more years, and then found out that they were innocent. I mean, not guilty, they were innocent, you know, through all the different things we have with current ways that we can process forensic evidence and everything else. I mean, we can get a fingerprint off the tip of a pin, if you watch CSI, okay? We could do things like that. We have all this digital awareness. I mean, we can Google so many things. Look at what we have in our pocket with our phone, the access we have. I'm confident we're not going to have a lot more of these incidents happening because we have more technical know-how now and more application in the law enforcement field, better education. But when we do get it wrong, we got to make it right. Dale?
And the inside baseball question, to answer your question, is that last session there was 2 representatives that were both very well-intentioned and passionate about this, and they had different solutions. So that caused some difficulty. Now both of those representatives are retired, and so that definitely helps out. Also, the process works out well, right? Is that sometimes when you introduce a bill previously, the process is a vetting process, and so we've taken the feedback we heard from folks on both sides of the aisle and addressed that. And I'll give you a good example. So let's say you have someone in jail because they had a false testimony from some expert, and so really it's not the state at fault, it's not necessarily the taxpayers at fault, but it may be a disproportional share of the reason that person's in jail is because of some bogus testimony. If there's a civil lawsuit and that person loses that lawsuit and they're owed $3 million, the state's then made whole for whatever the claims board is paying out that person. So there's a $3 million judgment, the state gives them $500,000. There's $500,000 that goes back to taxpayers to make them whole, and then the exoneree nets the $2.5 million. So that's what we've done is we've listened to that feedback and we've built the concerns within this bill that were not addressed previously.
Where's leadership in either house on this bill? Have you spoken with them, and what's the caucus support?
Yeah, I know Representative Voss is very much concerned about issues like this, justice issues. I mean, he's expressed concern about issues like this before, and I'm optimistic that, you know, he likes things to go through the process. The Speaker very, very rarely commits to a bill in this phase, and so I think the Speaker will see this bill as well go through the process, and you're more than welcome to ask his opinion on the bill personally.
Any idea whether it's since 1990 or what the date would be, how much money the state has paid out in lawsuits for wrongful conviction?
We wouldn't have that. We can attempt to get that information, but I think Keith has already alluded to the fact that that kind of information is difficult to come by. As I stand here, I would not have an answer to that question, but certainly I and my staff could, our staffs could get that information for you.
And there's two different forms of that. There's as mentioned earlier, there was the automatic process of the claims board, but then last session, Senator Grothman and I did a bill, particularly for Robert Stinson, to give him more of that board because that case, the wrongs, the injustices to him were so egregious, we felt like we had to do something. But real quickly, and we'll probably sum it up with this thought, is that what we don't want to give as perception, I think politicians, it's tempting to do this, is that we're delivering justice. And there's no amount of money that we could give these individuals that delivers justice. How much money is it worth missing the birth of your child? For not being able to develop your career? For having your mother think that you're a rapist or a murderer and all your friends? How much money is that worth? And the fact is I think for everyone in this room, you can't put a dollar on that. And so it gets kind of silly when you're talking about where do we go along other states and what the cap should be and what the years meant. It's all arbitrary, because what matters is all we want to do is give these people a start, to give some sort of apology in dollar form from the state of Wisconsin, and give them the ability to do what we all enjoy, and that is raising families, having a career, owning a home. And that's where I think we struck a good balance in this bill, and so we're very optimistic going forward.
You mentioned briefly that they must be found innocent, not simply not guilty. Who has to declare them innocent? A judge? You mentioned the Division of Hearings and Appeals.
Well, there's actually a special board for this in Wisconsin, and that board is there.
Is it the claims, not the claims board?
Yeah, claims board.
Claims
Yeah,
board.
yeah.
The claims
So-
board has to decide that they're innocent.
Exactly. So we're not changing any of the structures around it. So I mean, obviously you mentioned innocent. I mean, innocent's a whole different world. People are found innocent every day, and obviously there's injustices there too, as far as being incarcerated during that time. That's the way our justice system works in all 50 states. This is separate. And this is you've gone through the process. You were convicted. You find out subsequently that was a false conviction, and that determination is actually from a judge that they are actually innocent. And then following that, outside of the traditional judicial system, is this claims board. But the claims board's ability to reward monetary compensation is statutorily capped at that low amount that we mentioned earlier, $5,000
So
a year.
you have to have a declaration of innocence from a judge and then take it to the claims board?
Correct. I mean, even if there's, like, well, we just don't know where this case, there's not enough. I mean, some people are left out of jail and they're kind of left hanging there without even being exonerated or found. They're left out of jail in limbo. That would not necessarily qualify. And obviously that could then subsequently go through the court system, but that would be a different case.
You mentioned other criteria besides the declaration of innocence that the claims board has to determine. What other examples of other criteria?
I'm not sure I
Can I
understand.
I don't know if this is responsive, but if
Go
you
ahead.
don't mind, I
Go ahead.
think I can help clarify the process a little bit. So, once a person's been exonerated, the circuit court judge, the trial court judge, there's no finding of innocence, or the conviction is overturned, the charges are dismissed. Then what the person does is applies to the claims board for compensation, and the judge that I believe Representative Coenga was referring to is the bill provides that because this is such an intensive fact-finding process that the claims board doesn't really have the tools to do. What happens is that this bill says that then it's assigned to administrative law judge within the Division of Hearings and Appeals who conducts the hearings, and that's the judge who actually issues a finding of actual innocence under the burden that's imposed by the statute, and then it goes back to the claims board for final resolution.
So the would-be exoneree is gonna have to hire an attorney to take this through the process with the ALJ and the claims board.
Well, not necessarily, because what the other thing this bill does is it provides a right to a public defender to help them with this process. So they won't have to hire their own attorneys. They can go to the public defender's office, get that assistance, file the claim with the claims board, and then go through the administrative law hearing where that judge considers the question of whether they're actually innocent or not, and then refers it back to the claims board.
And do they have to hire their own attorneys under current statute?
Current statute, I don't believe it has any provision for counsel at all.
I don't believe it does yet.
You hire your own.
It's your own.
Just one thing, you mentioned transitional services available. Are those similar to the same services that a prisoner who
Yes.
is released? So the exact same or similar, or
Very
is that
similar.
still?
Very similar. So we want to give them the same fresh start that someone who served their sentence has to be a success in society.
Because there's obviously a time lag too before getting out of jail and having this all sorted out.
What are some examples of those services that?
Well, we alluded to healthcare. Certainly, if this bill passes, there's a up to 10 years healthcare, but that would be covered by there's not an additional benefit that the exoneree receives, but healthcare will be available, job training, housing, all the things that are currently available to those that.
Skills enhancement, education.
Housing?
Skills enhancement, education, those types of things, getting them into housing to help them with that. You know, it's basically being able to connect that person in the community so that they can get reinvested in the community that they're gonna live in. And that's a challenge today, especially if you've been out of the, if you've been gone and, you know, you were riding horses when you went in and now you came out and they're driving cars, it's a whole different thing. You know, that may seem like it's, you know, I'm not trying to make it funny, but it's like, that's the difference that it can be. When you're locked up and you're out of the world for that length of time, you know, you're watching stuff on TV maybe, if you're allowed to do that. It's not the same as being out there and walking through it and being out in the community. Things change. So we want to make it as friendly as we can for that individual to be able to reacquiesce into the community.
Last question.
Oh, easy enough. Well, thank you all, appreciate it.
Go ahead.
Again, can you just run me through the process of who needs to find who is innocent
Let me-
and what
let me-
entity needs to do that?
Let me read directly from the bill. Just as in current law, the bill runs the exoneree compensation program through the state claims board. Right now, the claims board is limited to that $5,000 with a maximum of $25,000 for wrongful conviction. The bill requires the Division of Hearings and Appeals within the Department of Administration to consider the compensation request. A hearing will be held at the request of DOA, Department of Administration, or the Office of the Original Prosecuting Attorney. The hearing examiner must find, beyond a preponderance of the evidence, that the petitioner is eligible for compensation. And then we go over the caps, 50,000 a year. That's the process that we're talking about. It's fairly similar to what we have now.
And that was my question. So what determines that they are eligible for it besides being declared innocent?
Well, and Keith has had experience with it in terms of getting some of the benefits paid. But I think bottom line is that if they're first of all, they're innocent, and the board determines whether compensation is appropriate, and you're saying, what is the criteria to determine whether?
Is there anything beyond?
But there's nothing, and I'll turn it over to Keith to correct me on this, but you never are found, like when a jury comes back, they never say, we find you innocent. They say, we find you not guilty. Right. So I believe it's the same here, is there's never really a formal declaration of innocence. Right. It's just, like you said earlier, the charges are dropped, and that guilty plea is then, the guilty sentence is taken off, but there's no formal, here's your innocence judgment.
But in order to let that individual out, they have to overturn the verdict.
Yes.
So in order to do that, it can't just be, well, we kind of think that this guy wasn't, you know, didn't do the crime. Example would be, and this is where we got a lot of these, was with DNA. Because we had a lot of cases that the evidence was retained, there was a lot of DNA evidence, but we didn't do DNA. So we've gone back, and I know we did this in Racine, they actually went back and started checking crimes that they had to make sure that they had the DNA matches. And I don't know if there were any that actually showed up that they weren't guilty, but I know that this was one of the processes we went through. I know there were some in the state that actually were. That's how they were overturned. So, I mean, the guy said, look, I wasn't even there. It's, you know, you've got evidence, you know, is there a way that you can check this? Well, maybe it was the same blood type, but it's not his blood. You know, so that conviction under circumstantial evidence, you know, that it's the same blood type, blah, 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 was not, it was enough to convict him at that point, but once they found out that that blood actually wasn't his, and then they get a hit on somebody else in the system that has a DNA sample on a file. That's why we've done legislation to allow, you know, officers to take the DNA of individuals that are incarcerated. This is why we have this, is so that we can clear these types of situations up so we don't wrongfully incarcerate people. So that would be one of those.
I'll try to make, so Senator Weingarter is right, there's multiple steps. The first step is to go back to the trial court where you were convicted and to overturn the conviction. And the system is deliberately designed to make that very difficult to do once a conviction has been obtained. So that's a very high hurdle to meet, to just get the conviction overturned, but there's no finding of actual innocence in those cases. There's a finding that the verdict, the judgment no longer stands, it's thrown out. At that point, then, the person files a claim with the state claims board alleging to be actually innocent, and then the administrative law judge holds a hearing if appropriate, And to answer your question about what do you have to show in order to get compensation, you have to show the burden is now shifted. In the typical criminal case, the burden is on the government to prove guilt beyond a reasonable doubt. Now in the compensation stage, the burden shifts to the person who was convicted. It's now their burden to prove that they are in fact actually innocent, and they have to prove that by a preponderance of the evidence. That's what they have to show to become eligible for compensation. Once that finding is made that they have met that burden, that they are in fact actually innocent by a preponderance of the evidence, then it goes back to the claims board, and the statutory $50,000 per year amount is then what they are awarded. At $50,000 for every year, and that $50,000 is then indexed to inflation so that we don't have to come back and keep tweaking this statute every year.
Every 5 years, I think.
Just the.
Thank you.
Oh, thank you.
Yeah, we have to go to another hearing.
Thanks.